The aim of this film is to give you 10 top tips to make you a more effective witness.
It's important to stress that as barristers, we're subject to our professional code of conduct, so we cannot coach you or tell you what to say. What we can do is tell you what to expect and things to bear in mind when being a witness of fact in any civil case.
Whether you're going to the Royal Courts of Justice, a county court or a tribunal, make sure you arrive early and you dress appropriately, as if you would for a job interview. When it's your turn to give evidence, you will move to a seat between the judge and the barrister. There, you will take an oath or affirm to tell the truth. There will be a file of the trial papers in front of you, including a copy of your witness statement.
There will first be some questions from your own barrister. That's called examination in chief. Then there will be questions from the other side's barrister. That's cross-examination. And then you may have some more questions from your own barrister. That is re-examination.
Read your witness statement.
It's your evidence, so if there is something in your witness statement which is untrue or not correct, you must tell your barrister beforehand so that it can be corrected. Whilst you don't need to memorise the contents of your witness statement, you should be very familiar with what it says.
Know the documents.
Some cases have numerous lever arch files of documents. If you're a key witness, try to familiarise yourself with the files in advance. Then, you can refer to any documents that back up what you're saying.
Answer the question.
Some of the worst witnesses are those who appear to be avoiding the question or anticipating what they're going to be asked. Just answer the question. If you don't know the answer, say so. Don't try and guess.
If you didn't understand the question, ask for it to be repeated.
There is no point and considerable danger in answering a question that you do not understand. In any event, the question may have been badly worded or phrased, so the safe thing to do is ask for that question to be repeated.
Speak slowly and clearly.
You'll be in a large room, and although there's a microphone in front of you, it only records and does not amplify. Therefore, make sure you speak loudly enough and clearly enough that everybody can hear you. The judge will be writing down everything that you say, so make sure you speak slowly.
Be careful with rolled up questions.
You may be asked a number of questions rolled into one. For example, were you at the meeting and did you sign the document? It's important to answer each part of the question separately, making clear that that is what you're doing.
Address your answers to the judge.
Face the judge when answering the question, but the barrister when listening to the question. Judges are called different things in different courts and tribunals, so ask your barrister beforehand what to call the judge.
Pay particular attention to any question the judge asks.
The judge is the one who's going to be making the decision. So if the judge asks you a question, you can probably assume they're going to be interested in the answer.
Stay calm.
Sometimes the person that is cross-examining you is trying to get you to lose your cool, or perhaps the subject matter could be quite personal or upsetting. Remember to stay calm. Your evidence will be so much the better if you don't argue back and you keep your emotions in check. Tell the truth.
You will have been required to swear an oath or make an affirmation as to the truth of your evidence. Lying on oath is perjury. Even small departures from the truth can lead to the judge discounting your evidence, even if you think it's immaterial.